Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we're going to discuss a judgment of Justice Gaurang Kant from Calcutta High Court. This is in specific about under Section 31 of the Specific Relief Act. Justice Gaurang Kant has held that disputes under Section 31 of say Specific Relief Act are arbitrable. But in this particular case, there is a special mention which we'll go into, where arbitral awards are not binding on third parties. That is what he said. What is the case? The details my panelists will share with you in the explainer. But let me introduce you my panel today. We have with us Justice Iqbal Ahmed Ansari. As we all know, Sir has served as the Chief Justice of the Patna High Court. We have with us Senior Advocate Sanjay Jain, who we all know has for long years served as the Additional Solicitor General of India. Now he's in private practice. Famously has also been a prosecutor in important matters. Good to see you, sir. I have with me Advocate Sri Venkatesh, who practices at ACTEL, the Delhi High Court, the Supreme Court, and NCLT. Good to see you, Venkatesh. At the outset, let me request Venkatesh to give an explainer on this judgment, and then we go for opinions to Senior Advocate Sanjay Jain and commentary from Justice Ansari. Over to you, Venkatesh, for explaining what this judgment in arbitration is about.
Okay, so this is a very interesting case, and I think something which as litigants or advocates we gloss over. So in this case, what happened was that multiple parties came together to pool their land for development of a project. So for that, they first executed a deed of exchange sometime in 2012. And after the lands were all amalgamated and exchanged for a common purpose, they also entered into a development agreement with the builder. Now, the builder itself could not do the project, so the matter went under arbitration, and award was written in favor of the parties, and the award cancelled this development agreement and also granted them liberty to cancel the deed of exchange, for which perhaps separate proceedings were required to be taken out. Now, ultimately, there was a second round of dispute because one of the companies were, I think, going through some insolvency, and therefore they initiated another arbitration where this award was not disclosed. So finally, the question arose in the High Court was that the award which cancelled the development agreement, was it binding on the municipal corporation to carry out the cancellation of deed of exchange? So the Honorable Justice Kant referred to the recent judgment of the Honorable Supreme Court 2021 by Justice Nariman, and then one followed by Justice Oak in 2024, to say that yes, while carrying out a declaration under Section 31 of the Specific Relief Act, it is an action in rem. But in this case also, the award was inter se partes and did not bind the corporation to automatically cancel the deed of exchange, which was entered into prior to the development agreement. And therefore, the argument, I think this was in writ jurisdiction. Therefore, the refusal of the corporation to cancel the deed of exchange was affirmed, and the writ petition accordingly was dismissed. So the idea was to decide the interplay between an award inter se partes, whether it binds the corporation while carrying out the effect of the award. That was the question, and I think the law which has been settled by the Honorable Supreme Court has also been followed and very succinctly put in this High Court judgment.
Point very well taken, Advocate Venkatesh. I'll go to Senior Advocate Sanjay Jain for his comment.
Section 31 in itself provides that suppose whether it is court or the arbitrator, if the adjudicating authority is persuaded to cancel a registered instrument, then what is the effect of that? The effect of it is this, that what is the use of the litigant who went to the court and got a registered instrument cancelled? He will not keep it in his pocket. So therefore, Section 31 itself permits that that person can or the registry of the court can send this particular judgment of the court to the concerned revenue officer or the registrar, so that he can make an appropriate entry in the records. So if the instrument is cancelled, then that is why it has correctly been pointed out in the judgment that ordinarily 31's decree is a decree in rem because it binds all. But then once it comes to the award, as we all understand that so far as an arbitration award is concerned, it is a byproduct of party autonomy, and the parties decide. So there is a now, with the advent of Section 2 capital A in the Act itself, there is a confidentiality to be maintained. So arbitration awards, by their very nature, are the adjudication in personam, not the adjudication in rem. So the objection of the municipality, as Venkatesh very beautifully explained the facts of this case, the objection of the municipality that it should be taken as a this award should be taken as a decision in rem was rightly rejected, because then in that case the purpose of the confidentiality of the award would have been defeated, one. Secondly, the way the award is structured, the interest of the revenue is secured. If you see that, the award says very categorically that after the de-amalgamation, the parties are at liberty to go again to the concerned registrar and have their documents registered. So the interest of the revenue is secured. So in fact, this municipality's objection, even on merits or on the question of locus standi, would have rendered it meritless. But Justice Gaurang Kant, in the very beginning of this judgment, had made it clear that I am deciding this only from this perspective. So he had very concise proposition to deal with, and he dealt with in accordance with the law. And why this judgment becomes relevant and important is this, that it demystifies many complicated propositions which are not so complicated otherwise, but because of the mixing up of large complex facts and because of the involvement of multiple authorities. So there is a possibility of this law being misunderstood. So he has correctly applied it, in my view. Now I leave it to Judge Saab to
So we'll go to Justice Ansari because you do a lot of arbitrations yourself. Could you sort of comment on this?
I think my both panelists have put it very well. We must remember that as far as arbitration proceedings are concerned, the awards or the award is binding only on the parties to the arbitration.
Yes.
It will not bind the third party. And that's why only litigations in rem in personam are decided. But the disputes which are of the nature of in rem, they will be out of arbitrability of the agreements, even if there is one agreement. Now, in this particular case, the learned judge says, and rightly, that as far as Section 31 is concerned, it allows, in terms of the Specific Relief Act, to interfere or set aside an instrument. But this decision will not be binding on the third party. So if you obtained a decision for cancellation of a deed, it will be binding only on the parties to the arbitration, not on the third party. That is what it is. It gives rise to another complex question which may have to be dealt with some stage. That as far as Section 31 is concerned, it primarily deals with suits. That means with courts in general. That's a public forum. But when you take it to arbitration clause, it is not public forum. It is a private dispute. And if an instrument is struck down by court, then it will be binding on the third party. But if it is struck down by an arbitration, then it will not be binding on the third party. Am I clear?
No. Can you share with us again, sir?
Meaning thereby that if an instrument is cancelled by a court of law, in that event, it will be binding on the third parties. That means even like municipal corporation or anyone, they will have to go by this. But as far as arbitration is concerned, if it is cancelled by arbitrator, the award, in that the award is not binding on the third party, only on the parties to the arbitration.
Okay. Point well taken.
Yes.
I'll go to Advocate Sri Venkatesh for his intervention here, and also largely on the question of the applicability of the Specific Relief Act vis-a-vis other cases like infrastructure projects and so on. Over to you, Venkatesh.
So Specific Relief Act, as we all know, has been amended in 2018. And after the amendment, there is a positive push towards ensuring compliance or performance of contracts, which are often, left midway. And infrastructure projects, there has of course been a section inserted by which injunctions ought not to be granted against infrastructure projects at the very asking. So these are the two broad amendments which broadly brought the issue of Specific Relief Act, made it more pro performance as opposed to pro breach. Because as we all recall, prior to 2018, the simplest answer before every forum used to be that the contract in its very nature is determinable. Therefore, I will not perform. You come after me for damages. You compute your damages. I will fight that out, and I will see what happens later in those arbitration proceedings. So that thing has changed quite a bit, which is a positive direction, at least insofar as infrastructure companies are concerned. Because here, infrastructure companies, while are uniquely positioned, because the manner of deployment is so extensive that seeking alternate performance creates a lot of hindrance and problems for them. Therefore, they insist on performance being carried out by a vendor or a selectee in terms of a tender process, so that this should go on. So that's the first part. Coming back to this case at hand, it was a very interesting case because the arbitration had actually been carried out under the development agreement, which is between the parties, owners, and the builder, which had an arbitration clause. But the amended award which was issued, which of course this was not challenged under 34, therefore the court also could not examine it from that perspective. The learned judge could not examine it from that perspective. But the final award which was issued also held this earlier deed of exchange to be nugatory, even though there was no arbitration under that agreement. So this is what I think weighed with the learned judge when he examined the issue and said, look, that is a question. This arbitration agreement or this award governs only it's only governs for inter se parties. It doesn't transcend beyond to the municipal corporation, who's bound to accept the declaration of the deed of exchange being negated or nugatory. So this was a point, according to me, which clinched the argument in favor of the corporation, and that's where the judgment was delivered in favor of the corporation itself. Of course, after this award not being challenged, I don't think parties will have to take too many steps to get that declaration also carried out separately. But having said that, the law as correctly applicable has been followed in this case, because otherwise, the moment this is a learning for all of us who advise our clients, that the moment the nature of this dispute of this nature comes in, where in addition to the principal dispute, which is inter se parties, there is also going to be certain steps required to be taken for rectification of status, or steps required to be taken to go to status quo ante, then those steps have to be planned right in the beginning, because there is a time limit. Another question which arose here was there's a time limit of 3 years required for a suit for declaration to be filed under Section 31 to ask that instrument to be declared as null and void. So these questions, of course, this issue the learned judge has not examined because that issue never fell for consideration. But imagine a situation that you've litigated an arbitration for 10 years, seeking a declaration of a developer agreement or seeking declarations under a development agreement, but you've not taken any steps to cancel the deed of exchange. And after 3 years, you don't even have that remedy available. So this is something one has to keep in mind while strategizing for clients when these large disputes take place, so that each step is followed independently and simultaneously, so that limitation as a problem does not accrue at a later date.
Thank you for the sharing. That we'll go to Senior Advocate Sanjay Jain for his comment on same Specific Relief Act vis-a-vis arbitration, vis-a-vis infrastructure projects, and his opinion on this. Over to you, Mr. Jain.
As rightly pointed out by Venkatesh, that the situation has changed now, because long back, since I think in one of the cases pertaining to the tender, the Supreme Court, perhaps it was some Tata case, where Supreme Court had an occasion to observe that we have to see the cost which is accruing to the public exchequer when these infrastructure projects are stayed at the drop of the hat. So that eventually led to the legislature rectifying that anomaly. And today, unfortunately, despite the amendment in the Specific Relief Act, this aspect is being ignored. And still, we see that lot many infrastructure projects are being stayed practically at the drop of the hat. So that is where we need to have we need to build some kind of a consensus. We should have more seminars to discuss about it, because the infrastructure is very important for the ecosystem of the business environment. And if the country has to progress, these aspects need to be taken care of. Other very important aspect which emerges, which the learned judge was not concerned with, so he didn't point out. But otherwise, if somebody had contested, then this award could have been set aside because for two reasons primarily. Because once it was hopelessly time barred, it was beyond limitation. But we have to see this award practically as a consensus award. Otherwise, because the parties agreed and the so far as the municipality is concerned, it came only for a limited right, and its stand was vindicated. So we need to be very careful, because the parties in this particular matter escaped any adverse ruling from any of the court, because they were all ad idem, the basic proposition that they need to recommence the whole exercise. So that is another aspect. The third aspect which we need to be very clear about is that when we speak about the cancellation of the registered documents, so cancellation of registered documents is something which requires an absolute clarity and agreement and consensus amongst the stakeholders of that registered document, because otherwise it can lead to a great deal of litigation, because once a document is registered, it creates valuable rights in the property. And so it has to be seen whether when you are going for an instrument, whether any minor is a beneficiary or there is any trust which is a beneficiary. And in that case, it is very important that all the stakeholders must have the competence to go ahead with that. It should be shown that it is in the interest of the stakeholders, etc. And also that is why even the registrars are not very lenient in cancelling the registered documents, nor are the courts. Now, suppose this matter had gone to a court of law, then perhaps this decree equivalent to this award might not have been passed. So it was that is the now that goes in favor of the arbitration regime, something which you could not have litigated and won in a court of law, where CPC, where all other acts, Evidence Act, Limitation Act, all are applicable in its full rigor and vigor. So here, because of the alternative dispute resolution system doesn't believe in those technicalities. So somehow this award came to be passed. And the honorable judge has mentioned, Justice Gaurang Kant has mentioned that I am not here in 30, nobody has gone in 34. I am not sitting as a 34 court. So he has decided this question, as Venkatesh has pointed out, in a writ jurisdiction. So from writ jurisdiction's point of view, all that ends well is well, it's all right. But the lesson to be learned, it's a very important lesson to be learned by all of us who are the servants in the justice delivery system, that the clients must be adequately advised that, look, if you have to have this kind of a situation, act with alacrity, and also choose your forum carefully and strategically, and follow the law the way it is structured. And that is why, as we say, in fact, this discussion which you have initiated, Tarun, leads open another very important aspect on which maybe we can take the benefit of Just Saab on some other occasion also, that what is the importance of strategy in the civil litigation or in any kind of a corporate litigation. So litigation is not just about instituting a plaint to be converted into a suit or some kind of a petition, litigation is 75% is strategy. So therefore, that and strategy in the interest of client and strategy in deference to the law, by accepting the majesty of law, that what Parliament has enacted must be respected. So therefore, within the legal framework, how do we get relief for our clients? So that is something which is also a thought process with this judgment of Justice Gaurang Kant opens. After reading the whole judgment, I realized that all these gentlemen who were engaged in this litigation, they got away with something which perhaps they could not have got away in a contested suit. So that's my observation.
Thank you for beautifully explaining this, senior advocate Sanjay Jain. I'll go to Justice Ansari with a different question. Do you think some judicial restraint required on granting injunctions as far as whenever infrastructure projects are concerned?
See, as far as infrastructure projects are concerned, there is now, earlier also there was a debate, but now it is clearly established by law, by the statute itself, that the courts have to be slow and not you granted, as Mr. Venkatesh has said, on the drop of the head. That will require some kind of a restraint on the part of the court, that you decide on the basis of the facts of a case. Not that there is a bar in the granting of an interim order, but then the court has to be very, very careful while granting the interim order, that it has a very strong case placed before it by the plaintiff or the petitioner for the purpose of enabling them to obtain instruction. Secondly, what I would like to point out is that under Section 31, an instrument is not cancelled by the court or the arbitrator. The court or the arbitrator merely gives a declaration and a direction that this deed has to be cancelled. And thereafter, it is for the competent authority to cancel that deed. There lies the problem. Because if it be with the arbitrator or the court, straight away the document can be, or the instrument can be cancelled, but which is not the fact. It is simply a declaration, and then it goes to the third party or another competent person. Now, one more thing is that as far as the situation of law today is concerned, even a fraud which has been created in execution of a document, that can be invalidated by arbitration. Earlier it was that no arbitration will be there. But today, arbitrability of such an agreement, which can go into the validity of a document, so to say, whether it is void or perpetrated by fraud, that can be looked into by an arbitration. And the arbitrator can say that this deed is void because of fraud.
So one small question, enlarging the debate this a bit, but we are seeing many contestants over wills these days in Indian business landscape, where wills are being challenged, and it calls for a forensic investigation of the document. Do you think that jurisdiction is working well in India? Because I've seen in the recent past many disputes in business families which hinges on wills. If you could throw some light on that as an aside.
As far as India is concerned, will can be held to have been procured by fraud. That is possible, or by obtained by undue influence. In any of such cases, the will has to be cancelled. What is important is that, as I told you, that even if an agreement is influenced by fraud, then that can be decided by an arbitrator.
Okay.
Okay. And but that decision will be binding only on the parties.
Okay.
The third important thing is that as far as the writ jurisdiction is concerned, let us be very clear that there is no bar in exercising writ jurisdiction. It is only self-restraint proposition that I will not exercise writ jurisdiction in such and such case. So when you have a writ petition before you, which requires to deal with one aspect of the law and not the other one, then why do you deal with such a writ petition? Because then you will be leaving the room for dispute as far as the other dispute is concerned. There is no logic. There is no imposition by law that you must decide a writ petition, unlike a statutory petition where you are bound to decide. Your writ petition, you are never bound to decide. Academically, as far as writ jurisdiction is concerned, or any jurisdiction, academic questions are not to be decided. But questions which are so linked with each other that you can't disengage one from the other. In that event, you can't decide one and leave the other. If you are unable to decide because of some limitation by law, you will might as well not decide the one which you have the power to decide. Am I clear?
Yes, sir.
Don't decide something which you can decide, but you are unable to decide the other dispute.
Yes.
Then why decide such a dispute? You can leave it to the parties, because you are on the writ jurisdiction and not. Had it been a civil suit matter, would have been different. But it was a writ jurisdiction, and it is complete discretionary, and the limitations are imposed by the court itself, not by anyone else.
Point very well taken. This was an interesting discussion that arose from the offshoot. We did a discussion with Justice Gaurav Khan, Judge of Calcutta High Court, his judgment. I would like to thank Justice Iqbal Ansari, ex-Chief Justice of the Patna High Court, Senior Advocate Sanjay Jain, former Additional Solicitor General for India, Advocate Sri Venkatesh. Thank you for your time. Thank you for discussing this judgment of Justice Gaurav Khan. We will be, of course, looking forward to more judgments from the Calcutta High Court, which we'll bring forward to you on the show. But thank you for this one. Appreciate your time and appreciate for joining us. Thank you so much.
Thank you. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.